Chapter 11 Basic Structure of the Constitution. Emergence of the Basic Structure. The question whether fundamental rights can be amended by the Parliament under Article 368 came for consideration of the Supreme Court within a year of the Constitution coming into force. In the Shankari Prasad case, 1951, the constitutional validity of the First Amendment Act 1951, which curtailed the right to property, was challenged. The Supreme Court ruled that the power of Parliament to amend the Constitution under the Article 368 also includes the power to amend the fundamental rights. The word law in Article 13 includes only ordinary laws and not the constitutional amendment acts, constituent laws. Therefore, the Parliament can abridge or take away any of the fundamental rights by enacting a constitutional amendment act, and such a law will not be void under Article 13. But in the Golaknath case, 1967, the Supreme Court reversed its earlier stand. In that case, the constitutional validity of the 17th Amendment Act 1964, which inserted certain state acts in the 9th schedule, was challenged. The Supreme Court ruled that the fundamental rights are given a transcendental and immutable position, and hence the Parliament cannot abridge or take away any of these rights. A constitutional amendment is also a law within the meaning of Article 13 and hence would be void for violating any fundamental right. The Parliament reacted to the Supreme Court's judgment in the Golaknath case, 1967, by enacting 24th Amendment Act 1971. This act amended Article 13 and Article 368. It declared that Parliament has the power to abridge or take away any of the fundamental right under Article 368, and such an act will not be a law under the meaning of Article 13. However, in the Keshav Nand Bharati case, 1973, the Supreme Court overruled its judgment in the Golaknath case, 1967. It upheld the validity of the 24th Amendment Act 1971 and stated that the Parliament is empowered to abridge or take away any of the fundamental right. At the same time, it laid down a new doctrine of the basic structure or basic features of the Constitution. It ruled that the constituent power of the Parliament under Article 368 does not enable it to alter the basic structure of the Constitution. This means that Parliament cannot abridge or take away a fundamental right that forms a part of the basic structure of the Constitution. The doctrine of the basic structure of the Constitution was reaffirmed and applied by the Supreme Court in the Indira Nehru Gandhi case, 1975. In this case, Supreme Court invalidated the provision of 39th Amendment Act 1975, which kept the election disputes involving the Prime Minister and the Speaker of the Lok Sabha outside the jurisdiction of all courts. The court said that this provision was beyond the amending power of the Parliament as it affected the basic structure of the Constitution. Again, the Parliament reacted to this judicially innovated doctrine of basic structure by enacting 42nd Amendment Act of 1976. This act amended Article 368 and declared that there is no limitation on the constituent power of the Parliament and no amendment can be questioned in any court on any ground, including that of contravention of any of the fundamental rights. However, the Supreme Court in the Manavra Mill case 1980 invalidated this provision as it excluded judicial review, which is a basic structure of the Constitution. Applying the doctrine of basic structure with respect to Article 368, the court held, since the Constitution has conferred a limited amending power on the Parliament, the Parliament cannot, under the exercise of that limited power, enlarge that very power into an absolute power. Indeed, a limited amending power is one of the basic structure of the Constitution, and therefore the limitation on that power cannot be destroyed. In other words, Parliament cannot, under Article 368, expand its amending power so as to acquire for itself the right to repeal or abrogate the Constitution or destroy its basic features. The donee of a limited power cannot, by exercise of that power, convert that limited power into an unlimited one. Again, in the Vaman Rao case, 1981, the Supreme Court adhered to the doctrine of basic structure and further clarified it would apply to the constitutional amendments. April 24, 1973, that is the date of the judgment in Keshavanand Bharati case. Elements of the basic structure. The present position is that the Parliament under Article 368 can amend any part of the Constitution, including the fundamental right, without affecting the basic structure of the Constitution. However, the Supreme Court is yet to define or clarify as to what constitutes the basic structure of the Constitution. For the various judgments, the following have emerged as the basic structure or basic feature of the Constitution, or elements, components, ingredients of the basic structure of the Constitution. Supremacy of the Constitution. Number 2, sovereign, democratic and republican nature of the Indian polity. Number 3, secular character of the Constitution. Number 4, separation of power between legislature, executive and the judiciary. Number 5, federal character of the Constitution. Number 6, unity and integrity of the nation. Number 7, welfare state, socio-economic justice. Number 8, judicial review. Number 9, freedom and dignity of the individual. Number 10, parliamentary system. Number 11, rule of law. Number 12, harmony and balance between fundamental right and the directive principles. Number 13, principle of equality. Number 14, free and fair elections. Number 15, independence of judiciary. Number 16, limited power of Parliament to amend the Constitution. Number 17, effective access to justice. Number 18, principles or essence underlining the fundamental rights. 19, power of the Supreme Court under Article 32, 136, 141 and 142. Number 20, power of the High Court under Article 226 and 227. Refer to the table 11.1, evolution of the basic structure of the Constitution, serial number, name of the case, year, elements of the basic structure as declared by the Supreme Court. Case number 1, Keshavanand Bharati case, 1973. popularly known as fundamental right case. 1. Supremacy of the Constitution. Second, separation of power between the legislature, the executive, and the judiciary. Case number 3. Republic and democratic form of government. Number 4. Secular character of Constitution. Number 5. Federal character of the Constitution. Number 6. Sovereignty and unity of India. Number 7. Freedom and dignity of the individual. Number 8. Mandate to build a welfare state. Number 9. Parliamentary system. Case number 2. Indira Nehru Gandhi case, 1975, popularly known as the election case. First, India as a sovereign democratic republic, equality of status and opportunity of an individual. Third, secularism and freedom of conscience and religion. Number 4, government of laws and not of men, that is the rule of law. Number 5, judicial review. Number 6, free and fair election, which is implied in democracy. Case number 3, Mindra Mill case, 1980. Number 1, limited power of the Parliament to amend the Constitution. Number 2, judicial review. Number 3, harmony and balance between the fundamental rights and the directive principles. Number 4, Central Coal Fields Limited case, 1980. Effective access to justice. Number 5, Bhim Singh Ji case, 1981. Welfare state, socio-economic justice. Number 6, SP Sampath Kumar case, 1987. Rule of law. Number 1. Number 2. Judicial review. Case number 7. P. Sambamurthy case, 1987. First, rule of law. Second, judicial review. Case number 8. Delhi Judicial Service Association case, 1991. Power of Supreme Court under Article 32, 136, 141 and 142. Case number 9. Indira Sahni case, 1992, popularly known as the Mandal case. Number 1. Rule of law. Case number 10. Kumar Padma Prasad case, 1992. Independence of judiciary. Number 11. Quixote Holohon case, 1993, popularly known as defection case. Number 1. Free and fair elections. Number 2. Sovereign democratic and republic structure. Case number 12. Raghunath Rao case, 1993. First, principle of equality. Second, unity and integrity of India. Case number 13. S.R. Bumai case, 1994. First, federalism. Second, secularism. Third, democracy. Fourth, unity and integrity of the nation. Fourth, social justice. Fifth, social justice. Sixth, judicial review. 14th case, L. Chandra Kumar case, 1997. Powers of the High Court under the Article 226 and 227. Case number 15, Indira Sahni 2 case, 2000. Principle of equality. 16 case, All India Judges Association case, 2002. Independent judicial system. Case number 17, Kuldeep Nair case, 2006. Democracy. Number 1. Number 2. Free and fair elections. 18 case. M. Nagaraj case, 2006. Principle of equality. Case number 19. I.R. Kelo case, 2007, popularly known as Ninth Schedule case. Number 1, rule of law. Number 2, separation of power. Number 3, principles or essence underlining the fundamental rights. Number 4, judicial review. Number 5, principle of equality. Case number 3, Ram Jethmalani case, 2011. Powers of the Supreme Court under Article 32. Case number 21, Namit Sharma case, 2013. Freedom and dignity of the individual. Case number 22, Madras Bar Association case. Point number 1, judicial review. Number 2, powers of the High Court under Article 226 and 228.